It's nothing to do with Stormont Break. I'm talking about state aid, where you said the burden of proof would be on the European Union to establish that there'd been a breach of state aid rules. That could only be done in the European Court, couldn't it?
That's not my reading of it, but I'm willing to...
What court would decide?
Sorry for laughing, but... Oh, Leonard, I hope you're all well. You remember this guy? Yes, this is Lord Thomas of Gresford, who the last time he questioned our James Cleverly, yes, the Foreign Secretary, he tied him up in knots about why the government was kowtowing to a now minority party, i.e. the DUP. Well, again, he did the same thing in last week's committee meeting about the protocol on Ireland, and about the Windsor framework and EU law and one or two other things as well. Absolutely hilarious, my friends.
The starkest difference between the EU interpretation and the UK interpretation of the framework is in relation to the Court of Justice of the European Union, because the EU has said there's no change to the role of the Court of Justice. The Court of Justice remains the sole and ultimate arbiter of EU law, and the UK government says that there have been changes. The UK's veto in the Joint Committee can only be challenged through independent arbitration mechanisms, and not the ECJ, removing the ultimate authority of the ECJ in areas in which it would affect day-to-day lives. So on the one hand, no change. On the other hand, the UK side, well, we got rid of the ECJ. What change will be made to the Court of Justice of the European Union's role under the framework?
So...
Sorry, James Cleverly, but it's not off to a good start, is it? Or do you?
And I don't want my answer to appear confrontational, but in your question, you have blended two fundamentally different issues. So we have always recognised, the PM's recognised, that when it comes to EU law, the CJEU is the ultimate arbiter of their law. When it comes to the issue which is often discussed, which is the application of the Stormont break, that will be done by an international arbitration in the same way that trade disputes are often resolved anywhere around the world. And they are fundamentally different things. So for the EU stuff, the EU's body, the EU's legal structure does the EU stuff, just as for purely UK stuff, the UK legal process deals with purely UK stuff, and on the that area on that Venn diagram where there is crossover, where the Stormont break is applied, then international arbitration will be applied to that. So the EU does not deal with UK stuff. The UK stuff does not deal. The UK law does not deal with EU stuff, and where there is a crossover, that will be done internationally.
These arbitration mechanisms that are in the withdrawal agreement are always subject to the caveat that if a point of European law arises, the arbitrators will submit that to the European Court of Justice.
Yeah, but that's
is there any change in that?
Yeah, but that's different to the ECJ being the arbiter. Now, I mean, case law can be derived, examples can be derived in international arbitration from any one of a number of places. That is not my understanding. I'm not a lawyer, but that is my understanding. That is not unusual. That is not the same as the ECJ being the arbiter.
No, I understand. The arbiters are the arbitrators are the arbitrators,
yeah.
and the arbitration will be governed by any ruling that the European Court will make on European law. That's the position, isn't it?
That's not my understanding. So the arbiters can can take points of international law in their arbitration. But I mean, if we're putting forward our case and and as I say, I'm perhaps drifting into into an area which I don't claim to be my area of expertise, which is international trade arbitration.
No shit, Sherlock. Dearie me. You could hear the cogs whirring in his head, couldn't you? Oh, Jesus Christ, this is scary.
But it is not, in my understanding, and I'm very willing to be corrected on this, is not in my understanding the case that an ECJ decision automatically directs the decision of an international arbitration.
Let me take another point. You referred earlier, when we were discussing state aid, to the burden of proof on the European Union to establish if any breaches of state aid European rules occur. A confrontation like that would obviously be settled in the European Court of Justice, wouldn't it? If the EU say the EU state aid rules, so far as they apply to Northern Ireland, have been violated, that would be decided in the European Court.
But if the Stormont break,
It's nothing to do with Stormont break. I'm talking about state aid, where you said the burden of proof would be on the European Union to establish that there'd been a breach of state aid rules. That could only be done in the European Court, couldn't it?
that's not my reading of it, but I'm willing to.
What court would decide?
Sorry for laughing, but if you don't laugh, you'll cry, won't you? But this man is in a position of power, and clearly Brexit, by the sounds of it, it's just absolutely boiled his brain over the last few years, hasn't it?
If we're going to international arbitration,
This isn't arbitration. This is a breach of the state aid rules, where you said the burden of proof would be on the EU to prove it. To prove it before whom? It's got to be the European rules.
Yeah.
Sorry for butting into Zoom, but the silence was deafening, wasn't it?
Look, it's entirely feasible. I'm misunderstanding the nature of the question because a definition of EU laws, as I said, and we've always said, is decided by the ECJ.
Yes.
If there is an application which has a detrimental impact on this divergence, then that is an example where the break might be utilised, and in that instance, the decision will not be made by the ECJ. So whilst you're right that the definition of EU state aid rules would be made by the ECJ, if that were causing the kind of problem, and again, I'm willing to double check my notes on this and confirm this if I am drifting off beam. But my understanding is that if any application were to be having a real world and detrimental effect on Northern Ireland, that is the circumstances under which the break might be applied. If the break is applied, then that takes it out with the jurisdiction of the ECJ. That's why I was making the point about the break. So if
well, the impression that's been given is that the Windsor framework abolishes the jurisdiction of the European Court in important respects.
I'm not sure that is what we've ever said.
That's what the European Union think of it.
No, I don't know about you on this, but who am I going to believe? Lord Thomas, who seems to me as though he's well over his briefs, or a man who doctored a video in the last general election to make a politician look like he didn't have a clue about what he was talking about in a TV interview. Who am I going to believe?
Well, we've never said that. So if
You've sold it on the basis that the ECJ is overruled by the Windsor framework, it doesn't apply, forget about it.
No, I don't believe we have said that, sir. What we've said is that the elected representatives through Stormont and through the Stormont break will ultimately have a meaningful say on anything that affects them. If there are decisions that the people of Northern Ireland and their elected representatives are very, very happy with, and they don't apply the Stormont break, then it is a moot point. But we've never claimed that the ECJ does not have jurisdiction over EU law. We have said that there are a small number of examples where EU law may still have effect in Northern Ireland because of our desire to maintain both the north-south as well as the east-west relationship between so within the UK and between Northern Ireland and Ireland. And what we have said is if that balancing act is causing real problems in Northern Ireland, there is a Stormont break whereby we can address those. The idea that we've ever claimed that we've abolished these things, as you implied in your question, has not been anything that's come from the UK government. If that's people's interpretation, that's not what we have said. As I say, the ability for the elected representatives of Northern Ireland to apply a break is the key. That is the key element, and once that is applied.
So you made it clear that the EU are perfectly right when they say that there's no change to the jurisdiction of the European Court.
When it comes to EU law.
Thank you.
Absolutely.
Wow. That was hard work, wasn't it? Jesus Christ. And this is a man in position of power. Absolutely hilarious. But anyway, who do you think is right? Was it Lord Thomas or James Cleverly? For me, Lord Thomas seemed to make perfect sense to me, but what do you guys think? Let me know in the comments below. Until the next time, I shall bid you farewell and take care, my friends.